Okay, let's switch over back to the proposition. I did find it very interesting that you focus on the Misuse of Drugs Act and the detention provisions therein. And I think it's quite a valid point that you have done. However, I would like to follow up on, I think it's Gloria, is it, who's mentioned 1,230 people have been rehabilitated through the magic of detention without trial under the Misuse of Drugs Act. And from what you are saying, I mean, this is the proposition as a whole were saying, not just you, Gloria, that prison is very harsh. The suggestion seems to be that detention under the Misuse of Drugs Act is not really so harsh. From my experience, detainees would rather go to prison than go to drug reformative centers. Right? So I would like you to explain to me why the very harsh regime of a DRC is aided by the fact that the executive authorities do not have to prove that the person who is subject to that detention is detained without the opportunity to show that he does not warrant to being detained. In other words, I am being sent for a very harsh rehabilitative regime, which involves a great deal of physical assertion and very little consideration for the medical dimension of my drug dependency. And even the fact of my drug dependency is not subject to proof. Why is this good?
First, it is actually not true that your drug dependency doesn't have to be proved. Much in the same way as being a national security threat has to be proven to an advisory board, there are several levels of checks and balance. But we think that this isn't really the core of this discussion, because I think in either situation of a trial or detention, both teams would be reasonably able to tell whether an individual is high on drugs. The difference is this. If you put someone into a courtroom where the punishments, as stated by legal precedent, and the desire for judges to set a strong deterrent is very, very high, you often condemn this person to...
Okay, let me just stop you there.
Okay, sure.
What you have just said is the punishments in a court system are not appropriate. That can be rectified by widening the scope of sanctions available to a judge. It doesn't address the fact that why this person doesn't get an opportunity to prove that he does not have to be sent for drug rehabilitation in the open before an independent tribunal.
Okay, thank you. I see the heart of your question. I think earlier, as we agreed upon earlier in the discussion with your colleagues, we mentioned that the CLTPA as well as the MDA was still open to objective judicial review. This means that if an individual feels he has been unfairly detained, even though he is not actually a drug addict, he can go to...
Okay, let me stop you there again. The important point that you said is if he can show that he has unfairly been detained. That's a question of procedure. As long as the executive authority can show that they have applied the procedure fairly, they've ticked all the boxes, judicial review cannot intervene. So if the reason why I'm being sent to detention, let's say I'm saying I am not drug dependent. I don't need to be subject to 6 months of a vigorous regime to rehabilitate me from drug dependency because I'm not drug dependent. Why am I deprived of that opportunity to prove that I am not drug dependent? Because under the MDA, I do not have that opportunity.
I'm sorry, I think we're going to be very consistent in our stance here. The instance in which objective judicial review, and therefore there's only procedural review left, is in the instance of the ISA, as was set out and affirmed in the case of Teo Solang versus Minister of Home Affairs. But the exception in the Constitution crafted for the ISA to remove objective judicial review only applied to the ISA. And this means that the other two instances of judicial review in the Misuse of Drugs Act and the CLTPA still stand. This means that in the same way, you can go to an independent tribunal to challenge the validity of your detention if you feel you have been maligned by the government in terms of your drug consumption. this still applies in the status quo under the Misuse of Drugs Act. So there is an independent tribunal that can give you judicial review.
Let me just ask you, one of the pillars of your arguments appears to be, for the proposition, is that we need to, see, I told you, don't ding me. Can you ding a judge? One of the pillars of your argument appears to be that the ends let me put it very shortly, the ends justifies the means. That means if we can stop a terrorist attack, then just detain the guy. Where do you draw the line? Should we then allow torture? Because that'll stop a terrorist attack too.
I think the question of where we draw the line in anything, in any kind of legislation we make, is always a very messy issue. But the stance of team proposition, to be summarized again, is this. We believe that taking preemptive action, in the sense ends justifying the means, is a principle that can be applied when making our decisions. But this has to be balanced against other comparisons of whether an individual's rights are being brutally abused and whether an individual has no means of recourse whatsoever. This is not the state of detention in Singapore. Individuals, as we've argued to you today, have access to a lengthy series of checks and balances to prove or to challenge their detention, even if it wasn't the courtroom. And second of all, there are independent checks, such as an inspection board, that can perform random spot checks on detention centers to ensure there is no physical abuse of human rights. So when you consider these two factors together, this particular balance is justified, but something like Guantanamo Bay may not be.
Okay, I'm going to ignore the inspection board that goes and inspects the premises, because that just simply determines whether I'm getting my one shower a day and whether I'm allowed to go to the toilet when I want to, etc. That's irrelevant to the topic today. The question is whether you've got enough of a check and balance, and I come back to my original question, is there enough of a check and balance? You've got an advisory panel that does a review once a year. Is that enough of a check and balance? Is the advisory panel given sufficient information to make that determination? Are they allowed to call for independent witnesses and independent information aside from what is given to them by the police? Where is the check and balance? One of the fundamental checks and balance in a trial process, whether it be inquisitorial or adversary, is the fact that it is a public proceeding. Just like your parliament is a public proceeding where people can watch and see and comment and give views on this. And the ultimate check and balance in a trial process is, whether it be inquisitorial or adversarial, is the fact that they have to do it in front of everyone, in the open public. And that is the fundamental check and balance. Here you don't have that. So how do you make up for that loss of check and balance?
Before you answer, just following on what Mr. Palmer has said, I just want to read you a definition of the rule of law by the Secretary General of the United Nations. This is what is defined as. The rule of law is a principle of governance in which all persons, institutions and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced and independently adjudicated, and which are consistent with international human rights, norms and standards. So wouldn't your proposition today be at variance with this definition of the rule of law?
Okay, I'll first deal with Mr. Palmer's question. Okay, the first one would be dealing with the advisory board, and in fact they do have all the powers of the court. They can summon evidence, they can summon witness accounts. The only difference, and the key difference, is that they're not under obligation to reveal it to the defense. So there is independent information, and the detainee has the right to representation before the board. In other words, he can get legal counsel in and can make his case before the board. So it is actually two-sided, what the advisory board considers. It just does not have to reveal the sensitive information which could compromise on national security completely to the defendant. So in that case, there is a certain amount of representation, but on the idea of the public as well, essentially what side opposition proposes we would like to point out that isn't much any better, because what they prefer is to keep the public out of the trial as well, and then the public cannot act as a check. But in our case, we think there is public disclosure as well, as in the the very means to which we find out about these cases that we are citing here is that the ISA publishes detailed reports, so the public and the media is able to pick up and take a look at the decisions and the verdicts made by the advisory board and by the president as well. So there is a certain amount of public disclosure. Yeah. But on the idea of the...
Except for the sensitive information which you referred to.
Yeah, but we want to keep that sensitive.
But that's usually the information that leads to the detention.
Okay, I think the heart of the issue is this. I think team proposition, if you boil it down to the heart of the matter, wants to acknowledge that sometimes when a government operates, it cannot always reveal everything to the people. And I think this is, whether you go to France or the UK or any part of Europe or the world, this is a principle that all governments abide by. They don't release things like classified sensitive military information. They don't release things like special reports on where their operatives or, like black operations are. If you look at the common thread behind all these things, it's because these are national security concerns, and revealing such special and sensitive information allows the other actors in the world to threaten our national security. And that is the same parallel that's being drawn here. If we reveal information in a public trial, all information, sensitive or otherwise, then that sensitive information has the potential to do so much damage to the safety of our country.
Let me just stop you there. How does a drug addict affect national security?
Okay, so that's a different slant of argumentation. I think as you guys yourselves will recognize that the kind of arguments you're asking us about the Misuse of Drugs Act is fundamentally different. The reason the Misuse of Drugs Act is important with regard to preventive detention is because it protects the individual himself. If we forced an individual into prison, gave him a very long prison sentence, as we've argued to you from the start of this debate, that hinders his rehabilitation back into society. So yes, we still stand for very important groups of people in society, just that in this case, the focus of that argument is not on national security, but on individual welfare.
One of the points that the opposition made is that this is going back to this inadmissible evidence being allowed. And there was a suggestion that this evidence would be obtained, let me put it delicately, by imaginative means of interrogation, right? In other words, they will be extracted under duress from the witnesses. Now the question I would ask you is, the major legislations that provide for detention without trial, ISA, Misuse of Drugs Act, and the CLTPA, nowhere do they explicitly sanction the use of force on witnesses. Right? Nowhere in the law of Singapore does it say you can torture witnesses to extract information from them if it is not going to be produced in court. Okay, let's make that clear. So that's the first thing. The second thing is, I find it very hard to believe that any Supreme Court judge sitting in a review will say, okay, this is not an open court, so I don't mind that this confession or these statements have been extracted by torture. I will give them due weight as if they are voluntary statements. I don't think that's going to happen. So, I would like to know why you state that evidence from torture will be usable in detention without trial proceedings.
Thank you for the question. So let's answer the heart of the question you posed us. And you asked us why we think evidence from torture can be used in proceedings in the advisory board. The first answer we have to this is to quote from the proposition: the advisory board is under no obligation to reveal to defense the evidence.
I would also quote from the proposition that they said we do not advocate that torture be used to obtain information from the witnesses and that evidence be used. That is what the proposition said.
Yes, we accept that they do not advocate that the use of torture be used. And we accept that the laws of Singapore do not sanction the use of torture. But we think that the fact that the laws of Singapore and the ISA do not explicitly prohibit the use of torture to gather information, and the fact that we have no way to check on whether the advisory board is using such evidence or not is dangerous. Because even if our Supreme Court justices today are good people, which we accept, and the members of our advisory board today are people who believe that torture shouldn't be admissible as evidence, there's no way of ensuring institutionally that in the future, torture and other forms of imaginative evidence, as you put it, will not be used to have an unfair trial.
Well, we talk about institutions, but you know there is no magic in institutions. This building doesn't give a special aura or a special power that prevents abuse. The strength of any institution is the strength of the men and women who make it up. And I think, like I said, in my mind, no Supreme Court judge is going to say, I ain't going to treat this evidence as reliable even though it comes from torture. It's not going to happen. I think we can take that as a given. And similarly, like I said, none of the legislations we refer to permit use of extraneous investigation powers. There's, in fact, I believe under the ISA they expressly mentioned that the statements must be voluntary. So the fact that it doesn't say you can't do it, that's not an argument. I mean, it doesn't say you can do it either. And I think we can take a presumption that no law in Singapore says go ahead, torture. Right? Carry on.
We accept that institutions aren't magical, but we think that the strength of institutions over individuals, which is the cornerstone of our democracy, is the fact that institutions lay down rules as to procedure, lay down rules telling individuals, this is what you can do, this is the kind of evidence that you admit, and this is the kind of evidence you should not admit. Which means there is no room for individuals to arbitrarily decide on what exactly the word inadmissible, for example, means, or what evidence is admissible when institutions don't prohibit it. We think inadmissible evidence also goes beyond evidence obtained by force or torture. It can include hearsay which is impossible to be corroborated, such as, I saw a person X do this, or I saw a person Y do that, and that's the kind of evidence we reject as well. But the other thing is, it's not just the process of detention without trial which we think is fundamentally flawed. We also agree that the outcome of this deliberation, the fact that an individual is locked up preventively based on a balance of probabilities rather than the fact that he is beyond reasonable doubt guilty, is wrong as well. So on two levels, both the level of process and the level of outcome, we disagree with detention without trial in Singapore.
And I'd like to thank the judges and the participants for that very engaging exchange. I think a good experience for the students to know what litigation lawyers face in court.